Today we will discuss the difference between common intention and common object in context of how unlawful assembly uses the concept of common object and common intention. And we will do that in the light of a latest case law where it has been very beautifully distinguished. Before we do that, it is important for us to just have an outline of the relevant sections that are involved. The first section which is involved and which we must discuss is common intention, or which relates to common intention, and the second one is in relation to unlawful assembly. I have only mentioned the relevant sections because the discussion in the case will be in context of these two provisions only. Of course, the discussion is much broader in context of both the concepts. So, limiting it only to what we are studying in the case law. Now, a general reading of section 34 tells us that when a criminal act is done by several persons in furtherance of the common intention of all, each of such persons is liable to the act in the same manner as if it were done by him alone. This section uses certain terms which help us understand what is the purpose of the provision. It says that you need to do something. You must be more than two people, and you must do that in the furtherance of the common intention of all individuals. This hints at the fact that it must be something which everyone is agreeable, more or less, in context of that particular intention, and each of such person becomes liable as if they had done the act alone. And therefore, the concept of joint liability comes in. And another facet of it, another form of it, can be seen when we discuss unlawful assembly. And therefore, these two sections very often are discussed interchangeably. When we talk of section 149 and unlawful assembly, we see that the statement made in the provision is that if an offense is committed by any member of an unlawful assembly in prosecution of the common object of that assembly, or such as the members of that assembly knew to be likely to be committed in prosecution of that object, every person who at the time of committing that offense is a member of the same assembly is guilty of that offense. The purpose of reading out the provisions is to explain and highlight that terminologies differ. While both sections point out to the fact that members will become guilty of the offense, or that it will act as if you have committed the act alone, this one uses the term common intention and the other uses the term common object. And this is what we will discuss further as we look into this case law, which deals with the subject in a very nice manner. The case that is in front of us is Vasant versus State of Karnataka. Now, what happens in the case? This individual, let us say A, is the husband of B, and there is his mother, the mother in law of the wife, who are involved in the incident. There is a quarrel that occurs between these two individuals, and it is important at this point to bear in mind that it was an old marriage of 8 years where they had 3 children. And during this quarrel, it goes to an extent where the mother in law pours kerosene on the daughter in law and lights a match. It is believed that the husband is present during the incident. And when we look at the sections that are made punishable on these two individuals, that is the mother in law and the husband, we see that he has been included on the basis of the fact that there was a common intention to commit the offenses against her. And therefore, while it was seen that in the lower courts, the decision passed was that they were not made answerable, in High Court, both of these individuals were made answerable, and therefore, our interest is in the husband who, under the ambit of common intention, was considered to have or to have been a part of the offense. So now, when the case has come to the Supreme Court has elaborated on when common intention is applicable, and furthermore, at this point of time, they felt suitable to also differentiate it from common object, which is the terminology and the concept included in unlawful assembly. Okay, so going forward, we now know the facts of this case by and large. We further see that it is said that this girl, this wife, suffers from extensive burn injuries. She's taken to the hospital by neighbors and she succumbs to the injuries through septicemia. Now, there is a dying declaration which is taken from this wife before she passes away, and it is seen that when the discussion of the dying declaration is there, or when it is put forth in the case, that again not much mention of the husband is there. We will have a look at that write up. Before that, we will have a slight discussion on what the counsel from the state said. The state said that the husband may not be directly involved because he didn't really match or put the kerosene or light the match, or in other words, has not directly been implicated in the alleged crime. Still, it is established that he was present in the house and it was expected of the husband to take necessary precautions to save the life of his wife. And the fact that he didn't do any of those things meant he had common intention to commit that particular crime. So, what is relevant is the argument put forward is that he is present and he does nothing, and therefore he has common intention to commit the crime. Of course, we'll continue to discuss this facet. Now we see that the dying declaration is in front of us, and predominantly the discussion involves about how she got the injuries, and she mentions the mother-in-law and only mentions the husband in context of the fact that he tried to put water on her to put off the fire, but it did not get extinguished, and at the time the residents of the lane took her to the hospital. So again, predominantly the dying declaration does not talk about the husband. Only in the end it is mentioned that he in fact tried to put off the fire, and therefore this does raise questions as to did he really participate, was he really involved in the commission of the crime, and that is the debate which the case law tries to answer. It is further said that it is important to note that in the dying declaration also the husband doesn't figure. He is not really mentioned largely, and it is the mother-in-law who is predominantly mentioned in the dying declaration. At this time, the High Court and why it gave the particular decision against this particular husband has been discussed, and the relevant para is highlighted. And it states that the accused was, if he was really about to save his wife, he could have done it when she was in this condition. And the extent of the injuries that she has suffered, and the fact that he was present at that time shows hostility, and the fact that he never bothered to take her for treatment, and that somewhere ensures that he wanted her to die. And in this context, in this connection, it was an omission which led them to believe that he was answerable for the crime. So this is the High Court's justification on why they want to bring him under the ambit of Section 34. And this has been reiterated by the Supreme Court. It says that according to the High Court, he has not bothered and he did not ensure that she survives. And therefore, according to the High Court, the husband could be said to be guilty of sharing common intention with his mother. The Supreme Court says that they are not able to understand this justification of the High Court, and we will see how they continue to decipher this particular incident and discuss what really common intention is. The court cites Om Prakash versus State and states that the word common intention of all does not ignore the intention of an individual offender. So, this concept mentioned under Section 34 does include or takes into consideration the personal intention of the person, of the individual persons involved in the incident. The common intention required under 34 requires that there is guilty, some kind of mental element that is present in the individual. It may not be up to the power of mens rea, but there has to be a mental element which is relevant for the offense that must be present in each individual. The charge, on the other hand, and now we see them differentiating it with unlawful assembly and saying that this is how it differs from 149. This is how common intention differs from 149, because 149 disregards the intention of the individual. As we saw when we read the section, it says that the intention of the individual members of the assembly altogether is not relevant. It disregards the same and concentrates merely on the common object of the assembly as a whole. They are not interested in the common intention of all. They are interested that if they have agreed to the common object as an assembly, as a whole, as an assembly towards the common object. The result of this position is that there may be cases in which a person might be guilty of an offense under 149 but may have had no intention to commit or was even unaware of the commission of that act. So it has differentiated and said that common intention has a personal perspective and it takes into consideration the role of the individual involved in the crime and how they have physically manifested it and mentally manifested it, while 149 on the other hand is only interested in the fact that have you that is there a common object to which all of you agreed as members of the assembly, and if that is so you become answerable, right? Even though he may not have had the intention independently to do the particular act. And this is very beautifully explained. This concept of unlawful assembly is beautifully explained by the judiciary by taking an example. And they say that suppose there is an unlawful assembly which is for the purpose of wiping out all members of a particular mohalla, right? And there is a person X who is a member of this assembly, unlawful assembly, and he discovers that his friend, old friend Y, is a part of this mohalla. Now, X may not want Y to be killed, who is his old friend, and it might still happen. And as it is mentioned here, that Y might still be murdered by this unlawful assembly. If it so happens, then X, if he was a member of that unlawful assembly, might be held guilty of an offense committed by another member of the said assembly even though the offense itself was committed contrary to his desires and even in opposition of his own intention, provided it is shown that X remains a member of the assembly. So, very clearly, the court has explained to us that unlawful assembly may be a situation where you are not mentally even wanting to be a part of a specific act, in this case, killing Y, but because you have agreed to the object, the common object of the unlawful assembly, even if you are not intending this particular act, you become answerable because you are compliant with the common object of the unlawful assembly. And this has been established here by the court. It says that the reason is that criminal liability under 149 of IPC is determined not by intention but by the various individual members constituting it having a common object of the assembly as a whole. What is not relevant is your intention, but the object of the assembly as a whole is something that you must be wanting and aware of. And anything that happens under that ambit is something you are liable for, whether you are intending it or not. And therefore, it has been further said that 149 requires no individual authorship of the offense. It has not been specified or defined, and the offense is alleged on the charge to be the act of an undefined member of the assembly. So you are answerable for another person because it was something which was directly or indirectly related to the common object of the unlawful assembly. Whereas when we discuss section 34, it states that the connection here is between the offender and the offense is closer and deeper. And this is now further explained how common intention under 34 requires more involvement of the offender. We must bear in mind at this time the husband who is involved in the case and whether he should be punished or not. That helps us clarify this concept. So, under section 34, every individual is associated with the criminal act, which constitutes the offense both physically as well as mentally. So, you have to be involved in the criminal act mentally and physically. In other words, the court has said the emphasis is both in respect of physical act as well as in respect of mental state is placed on the assembly as a whole in context of 149, and under 34 the weight is divided equally between both the individual as well as the entire group. So 149 only is interested is that what is the common object of the unlawful assembly, and if the act is done for that purpose, whatever might be your intention, you come under the ambit of the provision. 34, on the other hand, looks at both the individual as well as the group. It further states that while 34, in contrast of 149, balances between individual and general, it takes into account individual aspect as a part and parcel of the general aspect. Section 34 is therefore more restrictive than 149. 149, you are a part of the unlawful assembly. If you're working towards a common object, then everything you become liable whether you intend it or not. Common intention is more limited. It will look into individual uh, mental status and physical act involved, and then decide whether the person can be actually said to have had a common intention to commit the crime. Participation of the individual offender in the criminal act in some form or the other, which is a leading feature of 34 and differentiates it not only from section 49 but other offenses. And therefore the court is saying that what is necessary for 34 is that you participate. We know that in this situation the husband, his contribution is that he tried to put out the fire. Beyond that we are not aware. And the state states that a person who is present on the spot of the commission of the offense would be guilty by the application of section 34, although he did not do anything. So now there is a discussion on whether presence amounts to having common intention. And this has again been explained beautifully in this judgment. And the court states that a person present in the scene might or might not be guilty of the application of 34. If he is present on the scene for participating in the offense, he would certainly be guilty as a participator of the offense. On the other hand, if he is present as a spectator, he would not be guilty of the offense. So, in essence, the fact that you are present and participating is relevant. If you are a spectator, you do not come under the ambit of 34. And that's what it has stated, that presence on the spot for the purpose of facilitation or promoting the offense amounts to participation. So presence to ensure the offense is committed is itself an act of participation, and therefore 34 can be made applicable. Question again comes in is, do we say that the husband here, because he was present, would it amount to an act committed through common intention? This debate continues. The court further also mentions that those who serve, who they also serve, who only stand and wait, trying to imply that sometimes mere presence also can be counted as participation. They are also serving in certain circumstances who stand and wait if it can be shown that the waiting was in context of trying to facilitate the offense. And that has been further elaborated here by saying that when there is an expectation of help and it is necessary for the completion of crime, and that the belief is that the associate is near and ready to provide that help, right? And incite him to accomplish this act by the countenance and assistance of the accomplice, then in such situations, even though such person in essence is just present, he is participating in the commission of the crime. So this debate is also put forward that sometimes presence can also amount to participation. We still are left with the question as to is the husband here by being present participating? The word criminal act has also been discussed in the decision, and it says that it includes gesture, deed, conduct, or any kind of act on the part of the person, and that can be active or passive, which can be done for the common design that is involved. This can be done simultaneously where they both act together. For example, in this case itself, if the mother-in-law has put the kerosene and the husband uses the match, then in this situation, clearly they both have acted together and there is common intention. In some situations, the criminal act can be consecutive to one another, where one day one person has done some part and subsequently another person has done another part. So that has also been explained. Now, finally, the court is coming to a conclusion that in some form or the other, there must be participation on the part of an individual who must come under the ambit of 34. And the court feels that and states that we find ourselves unable to endorse the argument of the appellant learned counsel that a guilty associate merely present on the spot cannot be said to be participating. So the debate as to whether you are present, therefore you are participating, is something the court is still contemplating. It uses and highlights the term done and says this again implies that you need to do something to be a part of Section 34, to be under the ambit of Section 34. And it states again the difference between 34 and 149 and says that the difference between common object and intention is that though their object is common, the intentions of several members may differ and indeed may be similar only in respect that they are unlawful. While the element of participation in action, which is the leading feature of 34, is replaced in 149. So we don't see participation as an essential element in 149, which is of essence to section 34, which is an ingredient of section 34. The net result of the above discussion, the court says, is that although section 34 deals with the criminal act, which is joint and an intention which is common, it cannot be said that it completely ignores or eliminates the elements of personal contribution, and therefore personal contribution is relevant to common intention. Of personal contribution of individual offender is relevant to common intention. The court again makes a presumption in the case and it says that husband is present at the time of the incident. However, there is nothing to indicate that he shared common intention with his mother. When the mother-in-law poured kerosene on the deceased and set her on fire, it is possible that the husband, out of sheer fear and fright, may have run away from his house after trying to extinguish the fire by pouring water on the burning body of the wife. His sudden disappearance after this incident is not sufficient to infer common intention. And therefore, the court, based on this discussion, the fact that he tried to extinguish the fire, the fact that he may have been under fear and therefore disappeared after the act and did not try to provide medical facility to her, the court said that after an overall view, they have reached the conclusion that the mother in law has rightly been made guilty for the offense. However, there is a mistake in context of husband, in context of section 34, because that has not been established under under the said section in context of whether the husband had common intention. Simply the fact that he did not take her or did not provide medical facility does not imply he had an intention which is similar to his mother. And as we have seen consistently through the case law, the court is also trying to say that there has to be a clear, vivid form of act which you do towards contributing towards the crime, which really cannot be established here. Even as the court has said here, even if we presume that he is present, post his presence, post the usage of the fire or of when the mother-in-law tries to burn with the kerosene, he has tried to extinguish the fire, right? And therefore, this leads to not complete or enough or sufficient proof to say that he intended what his mother intended, had a common intended. Did he participate to the extent that is required for common intention? Can we actually establish participation which is necessary for common intention? And that's what the last half of this case law ends with, that participation and individual physical and mental element of the individual is relevant to 34, and what is in the end relevant to 149 is that the members of the assembly work towards only the common object. And in such scenario, it might happen, as the example very lucidly provided, that where X knew that the person there was his friend and he didn't want him to die or be murdered. If it is murdered by the assembly, and if that was related to the common object, even though X doesn't intend it, he becomes liable for the act. So the individual intent, the individual participation in 149 is not given as much relevance as the common object of the assembly. Whereas in common intention, there is a balance between what is the general group's intention, but at the same time, the individual's particular intention and participation is relevant, thus contradicting or different from section 149. I hope that I was able to create some kind of understanding of section 34 and 149 of IPC. I will just end with showing that they have been dealt with under section 3 subsection 5 of BNS, which is common intention, and 190 deals with unlawful assembly under BNS. Thank you, students. I hope you were able to understand the concepts.